Joining us now, as promised, counsel to Hunter Biden, Abbe Lowell. Lowell is a partner and co-chair of Government Investigations Enforcement and Compliance at international law firm Winston & Strawn. Abbe, it's really good to have you. Thank you for being here. This indictment is 56 pages long. It's highly detailed. Much of it is pulled from Hunter Biden's own memoir describing what he was doing and where he was spending money. You say this isn't fair. You say he's being politically targeted because of his last name. But the indictment, as the New York Times puts it, and I think accurately so, reads as a withering play-by-play of personal indulgence. Why shouldn't somebody who didn't just cheat his taxes, but avoided paying his taxes, refused to pay his taxes for many years, be held accountable?
Let's start with what you said, Katie. I want to show you this document. This is what U.S. Attorney David Weiss filed on June 20th after looking at all these matters for 5 years and came to the decision that the appropriate resolution was a 2-count misdemeanor for filing late and failure to pay on time. 2 pages, June 20th. Let me show you this document. This is a 56-page document that was filed in court yesterday by the same prosecutor using the same evidence, none of which is new, with 9 counts. What happened between June 20th and yesterday? The facts didn't change. They are exactly the same as they were. The law didn't change, so you have to ask what changed. What changed was the enormous political pressure that was put on the U.S. attorney when he made a deal that was appropriate for what the facts and law showed, to him deciding, I don't want that grief any longer. I don't want to be ridiculed by the Republican Party, of which I'm a member. And I don't want to have to go in front of Congress and testify anymore. So I'll just be a tough guy. And now I'm going to take 2 pages of a misdemeanor where millions of Americans file late and turn it into a 56-page document. That is the important question as to how the power of government works. And as to my client, he has well stated many times that at the depths of his addiction, something that American families have somebody either in their family or they know, is not behavior that he's proud of. But it doesn't make him into a tax felon in a 56-page indictment. And lastly, how many cases do you know in which somebody, who when he got sober and he got his act together, paid his taxes back with interest and penalties 2 years ago, only to face this kind of a document yesterday? So people should ask, what changed between June 20th and yesterday? And the answer is politics.
Did you find anything in discovery that points you in that direction? Anything maybe regarding Donald Trump's allies that points you definitively in the direction of this being a political persecution?
We don't have to look at discovery. You just can look at the public record. You can look at the moment that that 2-page document was filed on June the 20th and see the outrage that Chairman Jim Comer, Chairman Jason Smith, Chairman Jim Jordan all said. You can see the reaction of the MAGA right media and the president, former president of the United States, who went publicly and said, this is an outrage. This is a traffic ticket. This would be the equivalent of letting Jeffrey Dahmer go, I think Matt Gaetz said. And you don't have to look very far. That's on the public record. And I do want to point out that the timing of yesterday is not a coincidence. This coming Monday, in the first case that the U.S. Attorney's Office in Delaware brought, the gun charge, which, by the way, on June 20th, they were content to have a diversion agreement for somebody that was in the predicament of Mr. Biden and turn that into a 3-count felony. What changed? By the way, the only thing that changed there is the law on gun possession restrictions got looser, not more strict.
Let me ask you, I assume you're going to file a selective prosecution motion. Those almost never.
On Monday, there will be multiple motions filed in Delaware, some of which will be relevant to the charges that have just been filed in California, and people should pay very close attention to what those motions say.
What are you going to argue in that motion that's going to get you over the top? Because they almost never succeed.
Well, they never succeed because they don't have the facts that we have. I agree with your observation. When you have the former president of the United States, 3 Republican chairs of Congress, yelling and screaming that a deal that had been properly worked out after a 5-year investigation, when the U.S. Attorney's Office was acting in their best interest, only to change and nothing else has changed other than the politics, you have a very strong presumption that that's the reason why. Again, There'll be many issues raised in these motions. To basically argue them all at a small segment today doesn't make sense. We can talk again next week when you read them.
You talk about how a lot of this wrongdoing was done while he was under the influence of drugs and alcohol, and he was going through a dark time. That's well documented. But didn't he file these returns when he was clean and sober? Wasn't this filed in 2020 regarding 2018 when he was clean and sober? So wasn't he sober when he was attesting to all of the things in 2018 as being business expenses?
If you parse out each of the charges, which start with failure to file in 2016, which would ordinarily be beyond a statute of limitations, except that they're coming up with a theory to save it, to their felony counts, which are in 2018, I think we already made clear both to the chair of the Ways and Means Committee and to the Justice Department itself that in 2018, the year in which they say Hunter Biden did something bad in his taxes, he overpaid his taxes for that year by a long amount of money. And we put in a protective motion, notice for a refund. So when we parse out each of the years involved, like 2018 followed in 2020, one of the elements of the crime is that there's a tax deficiency, at least in the main charge that they make. There won't be a tax deficiency, which goes back to my point, which is if his name wasn't Hunter Biden, this would not have happened. There's been nobody in the District of Delaware charged with the kind of gun case that he has been charged with, who wasn't also involved in a crime or had a record, none of which applied to him for his possession of a gun for 11 days that was never loaded and never used. And there's nobody who is in a position to be owed money by the government to be charged with tax evasion. And more importantly, as I said, and the record is perfectly clear about, the U.S. Attorney's Office felt on June 20th, after 5 years, the right resolution were 2 misdemeanors, and now it's 9 different counts. That in itself requires an explanation, and they'll have to give that explanation in court.
But can I ask you again, was he sober when he filed these returns, when he attested finally that all of these expenses that he listed as business expenses, these hotel stays, the health care, et cetera, was he sober when he said those were business expenses?
I don't know which year you're talking about. I certainly know that he was sober
when he filed for 2018 and 2020.
So when he filed his tax returns in 2020, that was not random. The things that were filed were based on conversations he would have had with tax advisors and accountants and professionals. We'll stand by whether or not, okay, I can't sit here today, Katie, and tell you if there is a 25-page tax return and there's one thing on it that could have been relabeled as something else. That's not the point. People make mistakes or people put things on their tax returns, which the IRS response is, by the way, we'd like to do an audit. By the way, why did you do this? By the way, can you give us backup? How many people who have done that, the response of the government is no notice, change in position, and by the way, here's your 9-count, 56-page indictment. Nobody. And that's why we say if it wasn't him and it wasn't the U.S. attorney caving to political pressure, this would not be the outcome. Are
you going to go back and try to get another plea agreement? And if so, what are you willing to concede? I assume your goal is to keep Hunter Biden out of prison. What does a plea agreement that's fair today look like to you if you're not able to get this case thrown out?
I don't know why we're at the point of a plea agreement, but let's start there. There was a plea agreement. There was a diversion agreement. It came as a result of a 5-year painstaking, thorough investigation. It was agreed upon between the parties, and it was something the U.S. attorney believed in. He's the one who reneged. He's the one who took it back. So the question about whether there should be a non-litigated resolution, you might want to ask him, not us. It is very clear that he's not interested in any resolution because last time he did the right thing, all he got was grief and pressure from the Republicans. And he has made the decision, obviously, that he doesn't want to withstand that again. And as to what's going to happen in the case, I think this is a case that cries out for the transparency of what changed and what caused these counts to be filed. And that's what will be explored in our motions. And look, you got to believe in a system that will get to the truth of when, as I said, June 20th, 2 misdemeanor counts. Today, 9 counts about the same facts. The only thing that you can point through in the middle is the political pressure. Our system should reveal that. And once it's revealed, these cases should be dismissed.